Okay, in this case, the conspiracy to obstruct justice charge is based upon facts that while the defendant was in jail, charged with the criminal sexual conduct, he asked another person to fabricate a letter from I think the mother of the complaining witness to present to the prosecuting attorney, which purported to say that she had pressured the victim into making the statements, and so it was offered as exculpatory evidence, and it was fabricated.
This moment reveals a shocking attempt to manipulate justice. Fabricated evidence isn't just deception. It's a serious crime that can completely destroy credibility in court.
So he's been charged and convicted for conspiring to obstruct justice by doing that. I think on a preponderance of the evidence, that's a little bit different than two people talking on the outside, like, gee, should we rob a bank or not? And one of them goes and does it. The one who suggests it is not necessarily a leader. I don't disagree with that. But in this case, somebody who's charged with a crime, who then asks somebody on their behalf, I want you to go fabricate this evidence for me, and they do so. I think the defendant who's charged with the crime and is instigating the fabrication of evidence is in fact a leader in a multi-offender situation. So I would find on a preponderance that Mr. Truman was a leader in that situation. So OB 14 in file 7035 would be scored at 10 points. Any further objection to scoring for the people?
No, Your Honor.
So now we got to do more math. In file 6978, I've added 20 points to PRV 7, which brings the PRV level from 25 to 45 on grid B, which still is prior record variable D, or prior record variable level D. And offense variable, I've scored OB 11 at 0 points. That's reduced the total OB from 95 points to 45 points, which reduces the level from 6 to 4. So the guidelines range would no longer be 84 months to 210 months, but would instead be 72 months to 180 months with the habitual third taken into account. Is that math correct, Ms. Goodrich?
Yes.
Mr. Johnson?
Yes, Your Honor.
Okay, and in 7035, again, I've added, this is on Class E grid. I've added 20 points to PRV 7. That increases the total PRV from 35 to 55, which changes it from prior record variable level D to level E. On the offense variables, I've scored OB 13 at 0 points rather than 25, but I've added 10 points under OB 10. So I think that means total OV would be 20 points. 10 for OB 14 and 10 for OB 19. That means that the level is from 4 to level 2. Is that right? And that would reduce the range. We're at E2. That would be with the habitual third. Now, instead of 12 to 36 months, it would be 10 to 34 months. Is that math correct, Ms. Goodrich?
Yes.
Mr.
Yes, sir.
Johnson? Oh. All right. So now we have our advisory range. Mr. Johnson, anything you want to say on behalf of your client?
Your Honor, starting with 25, 70, 35. The court has already given, as part of the guideline, objective recitation, what had happened. My client should not have engaged in that. One of the things that is important to everybody involved in the judicial process is that the process, is fair, and there are no outside influences on the evidence or from one side or the other. And I know from the government standpoint, that is the chief evil of falsifying or trying to manufacture evidence of guilt. And the court, in fairness, should look at it the same when the defendant does do it. But I would like to state for the court that the obstruction of justice is the sentencing offense, and he gets an aggravated factor under OB 19, 10 points for interference with administration of justice. And I fully concede that at this point, courts of higher jurisdiction have not agreed with the defense positions that, you really giving somebody an aggravating factor for what is essentially a sentence of defense. When you look at the totality of circumstances, we'd ask the court to follow the recommendation, and on that matter, sentence my client to find some.
The defense tries to humanize the defendant, but the court focuses on actions over words. Remorse matters, but accountability and past behavior carry far more weight in sentencing.
Cost. As to 25, 69, 78, I do not believe after getting to know my client that he is the person that he appears to be on the screen. And I say that knowing full well that we are here now for the second time in which he will be sentenced on a sex offense. And I say that understanding that, he has pled guilty or to violating the trust of someone that should have been able to trust in him for protection. When my client is embarrassed, he is hurt for the hurt that he has caused. He has, accepted responsibility. He's, waived his exam. He's pled guilty and accepted responsibility for these offenses. He was blasted all over social media for this offense. He's going to be on the sex offenders list. And these type of cases, and as a product of Catholic school, all through the college, and when I talk to people and they talk about, or I talk with them about Catholicism and criminal defense, it really focuses on a principle that I believe that nobody's sin is greater or lesser than anyone else's. We've all sinned. We've all fallen short, in my opinion. Now, the law does not take that opinion. We have Class A felonies, Class B felonies, Class C felonies, Class D felonies. I understand that.
I'm a lapsed Catholic, but I was taught about venial and mortal sins, so I'm not sure that canon law agrees with you too. But we're not going to get into that, but adjudicating that question today. Go ahead and continue.
Thank you. My client, I do believe, is redeemable. I do believe that he is starting in that first step of conviction and repentance, and here accepting responsibility, acknowledgement of what he has done, and he knows that he can never make right what he has done. But he is here. He is ready to accept his sentence. We ask the court for a fair sentence, and based upon the guidelines, my client's previous record, we would still ask the court for what it is that we were initially going to ask. We know the minimum has now been lowered based on changes to the guidelines, but it was never our plan to come here today and ask the court for the minimum sentence. We still ask this court for a sentence of 90 months for the capital case, which I believe is fair, looking at the account of my client, that this not being his first criminal conviction, not being his first sex offense, but take into account that he did step up and take responsibility for the harm he's caused, knowing and understanding that it's not going to make it any better. The fact that he did that, he should have done it in the first place. But we'd ask the court for a sentence of 90 months.
All right, thank you. Mr. Truman, you don't have to make a statement today, but it is allowed. Is there anything you want to say today, sir? Not clear. Okay. Ms. Goodrich, should we hear first from the victim's mother?
No, Your Honor, just the victim speaking.
Well, can counsel approach again for a second? All right, so it says Paula's iPhone. Paula, we didn't want to put your daughter's image and statement on YouTube. She did just make a statement in open court. The prosecutor tells me that if she did so, that you possibly did not want to make a statement. Did you wish to make an impact statement at this time or no?
Oh, we were hoping that both of us could, but they weren't sure how that was going to work today. So
that's fine. If you want to make a statement, go ahead.
Absolutely. All right. So I'm here before you today to express the profound impact that this situation has had on my family. And the actions of Elmer have not only inflicted fear and trauma on my daughter, but they have also disrupted the very fabric of our family. My daughter endured suffering that no one, especially a child, should ever have to face. Witnessing her pain has been unbearable as a parent, and it breaks my heart to see the confusion and fear in my child's eyes. This has fundamentally changed how my children view the world. They now carry the weight of this trauma and lingering fears. Elmer's actions, having his wife writing a letter pretending to be me and trying to make me look like a monster to my children, is just inexcusable. I feel as though a dark cloud has been looming over our family, making it difficult to foster a sense of safety and trust. The trust we once had as a family has been shattered, and rebuilding it is going to take some time and a lot of support. The damage done is immeasurable. My daughter has lost precious moments of her childhood, moments that she will never get back. We are asking the court to impose the maximum sentence allowable, not only because Elmer deserves to be held accountable for his actions, but also to signify the pain that he has inflicted on our family. And that is recognized and taken seriously. We ask that he serves consecutively and the maximum penalty. I hope that through this process that my family can heal and create a future where my children can feel safe. So I thank you for taking the time to consider, our statements today with the impact that it's had on us.
Thank you, ma'am.
Thank you.
Okay, and before I take the prosecutor's recommendation, as we're hearing more about this letter, it does cause me to revisit one scoring question. On the CSC case, 6978, OV19 was scored at 0 points. However, OV19 is not subject to the McGraw limitation of scoring facts only for the sentencing offense, but for conduct afterwards. And afterwards, the defendant is conspiring to obstruct justice by fabricating evidence to avoid accountability. I think that definitely calls for a scoring of 10 points for OV19. I'd give both sides an opportunity to be heard on that question. Ms. Fipprich, people's position.
I would concur with the court, Your Honor.
Mr. Johnson, defense position.
No objection, Your Honor.
Okay, OV19 to be scored at 10 points. That brings the OV to 55, OB level to 5. So now instead of my revised scoring at 72 to 180 months with the habitual third, we're in the D5 bracket. So that would bring the scoring to 78 to 195 months. Mr. Johnson, I'm sure that doesn't change your recommended 90-month sentence, but because we've changed the range, I'll reopen any allocution for you if you wish.
Well, Your Honor, again, my client, we understand the minimum. It was never our intention to ask for that. We still ask the court for the 90. Sure.
Okay, thank you. All right, Ms. Goodrich, recommendations from the people.
Thank you, Your Honor. The defendant is 52 years old with 3 prior felonies and 8 prior misdemeanors. He's unemployed with a high school diploma. I would ask the court to consider to exceed guidelines here. I think that there's reasons to, given his criminal history. In 1997, he had a felonious assault, but in 2002, he had a prior CSC4. The PSI reflects that the victim in that case was 5 years old. And then in 2019, he was charged with a CSC4. It was pled down to an aggravated assault. Mr. Truman did receive the benefit of the plea bargain here today. I think that given his criminal history against children, combined with the statements from the mom and the minor child, give reason to exceed the guidelines. Thank you.
Thank you. Mr. Truman, if you please stand for the court sentence. In a first sentence in file 7035, the conspiracy to obstruct justice, there's crime victims assessment of $130, $68 in state costs, advisory guidelines scored at 10 to 34 months. It's been my position that the statute requires that to be mandatory consecutive sentencing because it was committed while in the jail. I have a plea agreement for credit for time served and no additional time. Based on my understanding of the statute, I don't feel that I can give him credit for that time. He stands convicted of that offense. To comport with the terms of the plea agreement, I will find reasonable grounds for a downward departure in that. The reason for that is to effectuate the terms of a plea agreement. And in that case, I will sentence Mr. Truman to fines and costs, as I've stated. That's the 7035. Then in 6978, we've got Mr. Truman at 52 years of age with 3 prior felonies and 8 prior misdemeanors, charged with several counts of criminal sexual conduct in the first degree that would have carried a mandatory minimum 25 years in prison. He's received the benefit of a plea bargain for the what amounted to a downward departure for the conspiracy to obstruct justice, and also the reduction from a 25-year mandatory minimum to a 30-year absolute maximum from the CSE third habitual third. That's a significant benefit. And the only fact that changed from the factual basis supporting this no contest plea, the only fact that would make it a first rather than a third is just the age of the victim, which is not factually contested. So really, Mr. Truman is receiving quite a benefit from that, which I think is proper for the court to take into account because it doesn't require consideration of any contested fact. It's just the age of the victim. So then we have an advisory guidelines range at 78 to 195 months after several challenges back and forth. That's an advisory range. And if the court's not going to follow that range, I have to state reasons for doing so and the extent of the departure. Here, I believe that there are grounds for an upward departure from those guidelines range. And that is the fact that, number one, as I've stated, Mr. Truman is avoiding a mandatory minimum 25 years on the CSC ones and mandatory or certainly discretionary, I would have done consecutive sentencing for trying to tamper with evidence while he's in the jail on those charges. Secondly, and even more compelling, this is not the first time that Elmer Truman is standing in front of a judge to be sentenced for sexually abusing a child. It is not the first time that he's convicted of sexually abusing a child. He's been 3 times charged with it. 1 time reduced to a non-sexual assault. He's been twice convicted now of sexually abusing a child. I repeat that because if we were to ask ourselves or ask the community or ask anybody in the criminal justice system, which people coming to court to be sentenced on a criminal sexual conduct 3rd degree should receive the absolute maximum that you can give them? I'm pretty sure the answer would be, have they done it before? And here the answer is yes. I believe that calls for the absolute maximum sentence allowed by law, which I believe is certainly proportionate to the circumstances of this offense and this offender. That means that I'm limited to 2/3 of the maximum. The maximum under my discretion of an habitual third statute is 30 years. So, Mr. Truman, I'm exceeding the guidelines and giving you the absolute, what's called Tanner max, and sentencing you to prison for 20 years to 30 years.
The judge makes it clear, repeat offenses, especially involving children, will not be tolerated. This sentence sends a strong message. Some crimes demand the maximum consequence.
You'll receive credit in that file for 275 days served. There's state cost of $136, crime victims assessment of $130, I'm also assessing $350 in court costs. And if and when you are paroled on the CSC 2, that would, because the victim is under 13 and you're 17 years of age or older, that would subject you to lifetime electronic monitoring upon parole. I'm going to assess that as part of the sentence.